Good afternoon, friends, neighbors, owners of Oakwood Harbor. I've been promising this video for a while, so I apologize that it's taken a little while to get it together. But there was information, and then of course new things pop up all the time. As you know, recently I posted a poll on there to get a list of names by request of the attorney of people who wanted to join the litigation against Oakwood Harbor for violating their rights as owners and other things that have gone on. I found it really interesting that only 5 people, 110 at last count I think, had seen the post, but only 5 people actually voted on it. So I started poking and asking questions, and come to find out, there's been some rumors going around about court liability, that by signing on to the litigation that you're liable in some way. Now, I had to get an answer from the attorney in order to address this and to give you the facts, as opposed to hearsay or information that may or may not be correct. But after speaking with the attorney, I have information to give you. Now, first of all, as always with all my videos, I pre-qualify this as I am not an attorney. Feel free to contact Ryan Ferguson at any time in the law offices of Ferguson right here in downtown Checotah if you have any doubt or any further questions that I haven't covered in this. This is my opinion. The opinion that was given to me by the attorney is of course going through me to you. So this is something that I'm going to explain to you how this works. And again, it is my opinion. If there's any doubt, feel free to seek legal counsel. It's not only feel free, but it's encouraged. If you have a doubt, then by all means make a few calls, even if it's your own attorney, and explain your situation and your question and get an answer from an attorney. So now that that's out of the way, on June 21st, the court case that's coming up is my civil lawsuit, which is liable for me. If I lose the case, then I will have to pay the attorney fees for the person that is representing Oakwood Harbor, and that person who is representing Oakwood Harbor is being paid through our assessments. There was money that was set aside for him to represent Oakwood Harbor in the case, and 5 of 7 of the trustees actually showed up for the court case that day, but no one told me that the attorney would be there. So this changed the ball game. Because I am liable to pay his fees, I asked for a continuance in order to get my attorney onto the court case. I was more than willing to match wits with any one of those 7 people, or all 7 of them, at the court case. We had people there as witnesses. They came in strength, saying that they were apparently witnesses as well. And also, the attorney mentioned that he had some kind of examples to show them or whatnot. So at that point, I realized that there's a big difference between going head to head with a person who is violating your rights, or a person that is in breach of contract, when you're talking man to man. There's a completely different ball game when you're talking to someone that is familiar with the court system, understands how the court system works, has connections within the court to ask questions and get information, and also has 8 years of training to do it. So that said, I made the wise decision at that point to get my attorney involved in it, and he is now. And he is doing what they call mediation right now with the Oakwood Harbor attorney, because they have to discuss it and figure out what to do with it. Their attorney came in and said, we have exhibits, and I think he maybe had a folder in his hand. I had 9 folders in this bag behind me over here, and I have plenty of exhibits as to the Oakwood Harbor not keeping up with their contractual obligations, and also too, basically I'm not getting what I paid for. Long story short is, yes, in my case, if you come and witness for me, you're not liable, because I'm the one who brought the lawsuit against them. If I lose the lawsuit, for whatever reason, which is highly unlikely, according to me and my attorney, then I would be liable to pay the attorney fees that were charged to represent Oakwood Harbor. So that's where the liability ends. So people like Bob Core, Robin Foster, and others who showed up at the court, thank you. And I would appreciate it if you could show up at the next court date. But I wanted to be clear that as a witness, you are not liable for my lawsuit. This rests solely on my shoulders. And now, the rumor that's going around is that if you sign up for the litigation, you will be equally liable. There's a difference between my civil lawsuit and the injunctive relief that we are seeking through the court system with Attorney Ferguson. The injunctive relief, if granted, we win. If it's not granted, then the judge will look at it and say, was this a frivolous lawsuit? Was this a lawsuit that was caused, or that was initiated to cause trouble for and just tie up the board of trustees? That is highly unlikely. And again, this is from Attorney Ferguson's mouth to me, and I am transferring it to you. So by signing on it as a litigant, if the judge felt that this was a frivolous cause, that Oakwood Harbor has been doing everything in their power to fix the roads, to fix the bathhouses, to fix the septic systems, if he finds that they have not overstepped their power by buying a tractor that's costing us $600 a month without putting it on a special assessment and getting owner approval, which is what has really made us come up short at the end of the year financially. If those things are not clear and evident, then it could be seen as a frivolous lawsuit. If it's a frivolous lawsuit, then yes, anybody who signed the paper and decided they wanted to fight the system would be equally liable. So let's say that the attorney fees were $4,000 to protect Oakwood Harbor Board of Trustees, and our suit was deemed as frivolous and meaningless, and he said not in good faith. Judge Bridges has been dealing with Oakwood Harbor for some time, and as we all know, and if you were in the courtroom that day, you would have seen it, because he read them the Riot Act again when they were going up for a lien, and because they take up so much of his court docket, and because of all the problems that Oakwood Harbor has had in the past and in the present. So he's not real fond of them as it is, and we're trying to make changes for the better. It's very unlikely that he would feel that this was not a good faith lawsuit, but if he did, or if he felt that it was frivolous and we were just trying to cause trouble, then he could order that we pay the attorney fees. So let's break that down a little bit. The original quote from Attorney Ferguson to handle this case from start to finish was approximately $4,000. So let's say that Oakwood Harbor says, well, we've spent $4,000 fighting this, and here are the receipts for the attorney and how much he has been paid. If 100 people signed up, then you're looking at about $40 of liability per person that actually signs up to fight the system. And again, I have to point out that this is if Judge Bridges sees this as a frivolous lawsuit, that we have no basis, that our rights were not violated as owners, that we have been heard and we have been answered and we have all of the facts in front of us, that this would be a frivolous lawsuit, and he could, if he felt so inclined, to order the attorney be paid from us as opposed to from Oakwood Harbor. But quite honestly, if you think about it, no matter how you look at it, Oakwood Harbor owners will be ending up being paid in the long run anyways, because they're hiring an attorney to defend the Board of Trustees. So even if the case is lost, it's paid for out of the pocket of the assessments, just like has been happening ever since the minutes of the meeting showed that in September they were consulting with him, not only for how to work it where they could get the assessments that were past due, but also look into the possibility of turning Oakwood Harbor back into a campground again as opposed to people living here full time and all these extra services. So they've had a plan from the beginning, and they've been paying an attorney to consult them on this from the beginning. And I don't even believe that he really even knows the bigger story just yet, but he's about to find out because we've already paid the retainer. And I want to point that out too, is our attorney, his original quote was $4,000 from start to finish. But because he's a member of this community and he has defended many people in Oakwood Harbor, both against the trustee board and against each other to settle disputes in small claims court, he understands exactly what's going on. He has seen every piece of paperwork that is in my 9 folders that I expressed earlier. He has also received digital information from me. He's also received a copy of the meeting that was recorded by Courtney Wright, and thank you again, Courtney, for recording that meeting, because there's so much information in there and so much proof of how the owners are being abused that it went a long way. But all of this information in mind, and he's done part of this as a pro bono. Basically, he reduced that initial amount from $4,000 down to $2,000, and that would only be from start to finish. Now here is why they were asking for the names. The very first thought was, tell everybody to come down here that wants to join this suit, and they can make a statement here, and we'll take their statement and we'll add them to the list. Well, the response was apparently much more than they expected. Robin, for instance, tried to make an appointment, and they told her, well, hang on, we're trying to organize this for a day because the response has been so large. And so I looked back into it again and spoke with Attorney Ferguson to find out what was going on, and in order for him to stay within that original $2,000 quote to fight these people, which again, private owners have paid for, myself, Robert Coher, and a number of individuals who I won't mention at this point, but we've had people that have actually donated to his initial retainer. The reason I'm bringing this up is because I want you to know that he has enough faith in winning this case that he reduced his fee by half, and a lot of that work that they're doing is basically on him, pro bono. That's the best way I can explain it to you. But in order not to go beyond that $2,000 quote and to create more work than they're getting paid for, they asked me to acquire a list of names of the people, and then what they would do is get the paperwork together and take one whole day and set it aside for anybody who wanted to come in and sign on the line as a litigant, as a person who feels that their rights have been abused by Oakwood Harbor, and that the motion that was made during the meeting was legitimate and was enforceable. Once this happened, then it would keep us within the financial structure that we had already discussed and agreed to. But all of a sudden, I put this out there and I'm not getting any answers, and the rumors are coming from various areas, from other owners, from the office itself, and those rumors are that if you sign on the dotted line, you're liable. Okay, that is correct, but you have to understand, and again, consult an attorney, talk to Ryan, and see that if Judge Bridges finds what we are asking for, which is to protect our rights as the owners, to hold the board accountable for what they have not done, to hold the board accountable for what they have done that has been frivolous or against owner interests, that's what he's going to look at and decide whether or not this lawsuit was placed in good faith. If it was not placed in good faith and it was frivolous, then yes, he could rule that we pay for the attorney's fees, and anybody who signed would have a portion of that. Obviously, depends on what the amount is, and it depends on whether or not 10 people sign or 100 people sign. So the more people we have signed, the less the liability will be. Like I said, if it was a $4,000 bill and it's split up between 100 people, that's $40 a piece. Less equals more. But I have his assurance that with our information, and the moderator was there, you can see, and if you weren't at the meeting, please watch the meeting video. you will see where they refused to speak with our attorney, with our representative from the law office that was on site, telling them that they were wrong and asking them for a copy of the covenants, which they would not produce, and they were 100 feet from the office, and they shut down the meeting immediately or just moments after they were done. In other words, they didn't take all that, we'll do the question and answer at the end. They never did it. They shut it down. And now that I have the minutes of the meeting from April 17th, they already discussed that if it got out of hand, that they would shut it down. So for those of you that are unaware of all these things, I'm trying to bring this information to you as promised, because as we know, they don't bring you any information. Now, I also found another piece of interesting information while all this was going on. A lot of owners were calling me and calling Bob and wanting to know what was happening. There's another website or group out there, Facebook group out there, that is owned by a private owner, administrated by a private owner, and has 350 members. It's called Oakwood Harbor, but it's hidden from view. The groups can be hidden, and you can be admitted to that group by invitation only. Now, this particular administrator is on the board of trustees. I won't mention any names because, we've had our own problems with the mentioning of names and them trying very desperately, unsuccessfully, to get us for slander. And to do that, you have to not be able to prove it, and we can prove it. I have screenshots of it. The owner that brought it to my attention gave me information, but I'm not going to mention any names, like I said. But that group, that 350 member group from a trustee administrated individual, allowed the minutes of the meeting for this past May to be posted on that group for them to be able to view. But even Ted brought it up and said, wait a minute, the official group, which has been an argument from the first place because it's not in the bylaws of any official group or official website or any official way of doing business, but he argued that because his group was the official group, the one with the anchor, that it should be placed on his group. Well, in the end, the person who recorded the meeting decided that it would be better to put it on the group that has more owners. And I hate to tell you this, but at 190 owners, Ryan checks. I was a moderator on there until I backed out. And Ryan checks these things, and he makes sure that the people that are on there are owners, or they're a husband and wife, or whatever the case may be, and we're only at 190. For 350 owner members to be legitimate and seeing our personal information when we, the owners, who are paid in our assessments, who are legal owners that have done all of the legal things that we're supposed to do, like registering with the county, registering with the office, paying our assessments up to date, paying our taxes up to date, we are being prohibited. I had someone send me an invite from that group, and I was blocked out. Much as my wife has been blocked out, friends that I know have been blocked out. So what I wanted to make you aware of is they have this group, and they're sharing the actual minutes of the meeting as it was recorded without giving all of the owners the opportunity to see those minutes of the meeting. In most cases, as you all know, we have not got the minutes of the meeting until just before the next meeting. So anywhere from 3 weeks to 4 weeks after the meeting has taken place is when it gets transcribed, because someone broke their arm and can't do it. But yet they can talk into a phone and post on Facebook. It makes you wonder. Voice recognition has been in use for a long time. Why can't you transcribe the records that way? There is software that does it. But the point being is that for those of us that are not in the loop, in the friendship mode, in the family, whatever you want to call it, we're not able to see those minutes, even though we are legal owners that have met all of our obligations, and their friends and family, owners or not, it's yet to be seen, but it is being investigated. They get to see the minutes of the meeting. And I found that very disturbing, and I wanted you to know that as well. this pretty much covers everything that I wanted to talk to you about today. Other than my own situation, a lot of people have asked, well, why are you getting ready to sell out? Because first of all, I bought a half an acre in Muskogee County that is actually zoned farmland, so I don't have to fight with these yuppies any longer about whether or not we're allowed to have animals. Second of all, because there is a risk involved, there's a lot of shady practices, in my opinion, that have been going on for quite some time. So I felt that it was wiser in the long run to just sell my lots and to move closer to the Tulsa area where most of my contracts come from, and shorten my drive distance and things like that. But also too, because I also am very good at reading writing on the wall. There's not enough of you interested. There's not enough of you fighting the system right now. You're not willing to take a chance on $40 or even $100 when Robert and I have put thousands of dollars on the table in retainers, in research tools. In other words, we have to subscribe to the county records in order to pull county records and see what's going on, such as a huge purchase just recently of 10 lots, practically a whole street, for $55,000 from an outside investor from another state. It's not unusual to see somebody come in and pay a high price for a piece of property if it's got some real good improvements on it. But for these 10 lots, $55,000 averages out to, about $5,500 a piece, which is unusual unless they're all priced. Like in my situation, I have 4 lots altogether that I'll sell in packages of 2 and 2 because they have electric, they have fiber optic internet. I've done a great deal of work with putting in the gravel that the invisible gravel never took care of, fixing the roads, putting in a driveway. So I was looking at $15,000 for 2, $15,000 for 2, so $7,500 with improvements it's not unusual. But to buy 10 lots that have small amount of improvement and practically a whole street, that's kind of unusual. So with all these things in consideration, and the fact that we have such a lackluster support system when it comes to the owners, and I understand those of you that are on unemployment, those of you that are on disability, people that have just had tough times, I understand you can't financially put yourself at risk. But if this homeowners association falls apart or goes back to being a campground or whatever, which these are all things that are very, very unlikely, but if they did succeed in making this into something else, chances are you would lose the place that you live. So I think it's prudent to say that $40, $100 liability might be wise, as opposed to losing your place altogether. You've already lost your trash, the bathrooms work periodically, water pipes are always breaking, the septic system is always backing up, so you don't have a place to dump. There's a lot of issues going on here right now that could cause Oakwood Harbor to fail. And the people that are running it are the first ones in 38 years to start taking services away because of bad judgment calls that they made, such as the tractor and a $600 a month bill that they never approved through the owners. So it's up to you what you want to do. But the facts are on the table that yes, there is a very small chance of a liability being on you if the case is lost. But the chances that the case is lost, especially since our moderator was there on site, knows everything that happened, we have a recording of the meeting, that's very, very unlikely. So it's up to you. What I'm going to do is I'm going to watch out for me and my wife, my assets, my dogs, and we're going to move our stuff to the Haskell area, Muskogee County area where we bought our property, and that's where my new office is located. And then I'm just going to wash my hands of this if there's not enough response, because we need the owners to be behind this. If you're not behind it, then that's okay. We're just making plans. Same thing with Bob. Bob's not going anywhere. He said he'll fight to the bitter end, but he has made plans for a septic system and a well if necessary. I can't tell you anymore. All I can say is it's in your hands, but I wanted you to know the facts as I promised that I would give you this information. Have a great day. If you have any questions, post them. I'll see if we can get around to answering them.